ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I know they're watching. Ancestors watching. I know they're watching. I need some healing in my life. Someone who cares like Brandy cares. Yes, someone who shares all of the joy of family. One who believes we can be free. Yes, we can be free. Healing, 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 healing. Mind, body, and soul, yes. Mind, body, and soul, yes. Healing, 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 healing. Mind, body, and soul, yes. Mind, body, and soul, yes. I need some incense and some sage, natural capacity to pray. Live off the land, yes, live off the land. Lend me some oil from the tree, give me some lavender quickly. Heal from the pain, heal from the pain. Healing, 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 healing. Mind, body, and soul, yes. Mind, body, and soul, yes. Healing, 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 healing. Mind, body, and soul. Mind, body, and soul. Healing, 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 healing. Mind, body, and soul, yes. Mind, body, and soul, yes.
You know my galaxy was built for you and to fall. I recognize you in these constellations. It ain't complicated. Your prototype is algebraic. You fit my equation. Hold up, John. Let me sing it. I need your body and soul. And I'm done explaining 'cause I told you that I want you.
All right. Thank you all so much for being so patient, and for all of our lovely latecomers, welcome, welcome. Um, my name is Edwan Whitehead. I am going to be the moderator for this lovely panel today. Um, I just wanted to take a second to introduce our lovely panelists before I pass it to Dr. Carmen Johnson to ground us and share her story with us on as to why she does this work. Um, big shout out, of course, number one to Darren Browder of CourtWatch NOLA. Love working with you, appreciate you, happy to have you on the first panel, and looking forward to having you on many more. Um, Also, to shout out to all of our CourtWatch PG folks in the building. And another big shout out to a familiar face who I have never had the pleasure of meeting in person. Judge Joe Brown is with us today. and I'm happy to have him here. Um, and so, with that, I want to ground us with passing it off to the director of CourtWatch in Prince George's County and the director of Judicial Accountability for Life After Release as well, Dr. Carmen Johnson.
How's everybody doing? I am so glad that you all are here to join us to learn about why we court watch and to also consider creating a court watch organization in your community as well. And I kick that back to Edwan. Can't hear you, Edwan.
So, big intro for our panelists today. Thank you, Dr. C. Um, so we've got a few folks from a little spread out around the country still, as always. We've got Jesse Manley representing CourtWatch NOLA as a volunteer coordinator. We've got Carolyn Hoffman of Montgomery County, Maryland's CourtWatch program, as well as Professor Elizabeth Nevins from Hofstra University, the Dean School of Law, and her students also do a CourtWatch program at the university. So I'm looking forward to hearing about that as well. And Dr. C will be jumping in and out today with our panelists because her input is so important as always. And so I'm going to always include her in everything that we do. And so without further ado, I do want to kick it off and give our first question. Um, Give me 1 second. I'm trying to. I want to kick it to you, Jesse, because we know that volunteers are very important to this work. And for those of you that are currently volunteers, thank you for spending your time because it is so valuable to our organizations. And for those of you who are thinking about volunteering, don't hesitate to do it because it's absolutely needed. And we, in this fight for freedom, liberation, and making sure people are not in cages and being treated fairly, we need all hands on deck at all times. And so I want to kick it to you, Jesse, and just kind of ground us in a little bit of this because your background's really in the volunteer realm. So give me want to ask you what is something that you can give to the group about just recruiting? What is some of the strategies that you utilize to recruit and maintain volunteers in your organization?
Yeah, absolutely. Thank you for the introduction, Edwan. The Our organization is almost 100% volunteer driven. We release a report every year that makes recommendations to the justice system, but it's data driven based on data that volunteers collect by sitting in these proceedings. And we literally could not operate without our volunteer corps. So we've had an explosion over the last couple of years in volunteer participation, which has been fantastic. We have a lot of school partnerships, which have been really instrumental and allow us to do some very nice things like focusing in on specific courts when we have a class that can do something like take over like an entirety of a municipal court docket for a semester. So having that sort of constant flow of volunteers coming in is amazing, and definitely don't want to downplay that for a second. But one of the things that we put a very large focus on is recruiting lay people from the community. The approach that we take to court watching is that this is the people's court, and the transparency is essential for the average citizen to be able to walk in off of the street and sit down in a court proceeding and not only have access to sitting in the building, but being able to understand what's going on. And so we really like having lay people that don't have JDs that can sit in there and learn about the process in our training and then see how that process carries out in the courtroom. And they do, I think, consistently do way better than they think they're going to do. So we have a lot of people who have a lot of trepidation when they come to the training that like, oh, I'm not a lawyer. Am I going to be able to pull this off? And so we start from the jump. The very first training, we're talking about how this is not something that is just for lawyers. It's something for every person in the community should be able to do this and should be able to understand what's going on in court. So we look at that as, you know, not having a law degree as not a bug, but actually a feature. And it keeps us grounded too, because there are things that, you know, as we sit in court more and more, they just become more commonplace to us. And when we have a new trainee that sits down and they're like, I didn't understand that, what was that? It reminds us that, like, hey, this is something that could be confusing to the public. And so we need to put a greater emphasis on that in training. And then biggest thing is the information that we can give them about how the criminal legal system works. They can take that back into their community. And that's something they can share with the people who are being most negatively affected by these policies. And, you know, that's like, our students can do that too, but they're not always, you know, they're a part of our community while they're here for their 4 years in school, but they will, a lot of them will be going back home to somewhere else. And the people who are coming to us that live in this community full time, there's just a lot more of that, the education that gets to stay and that gets shared again with the people who are really bearing the brunt of these discriminatory policies. So that's a big part of why we look for people who aren't lawyers to come do this work.
And so again, for all you folks that are trying to volunteer, listen to the man. He knows what he's talking about. I do want to also, let me pass it over to you, Carolyn. I want to kind of hear about, what do you think the benefits are of court watching for all the folks in the room?
Actually, I'm so glad that question came up, because just exactly like what Jesse was saying, we really feel like there are three main benefits. And the first that we think is the most important part of court watching is really including community members. So we believe that not only can regular people be collecting data, but that they should be the ones who are collecting data. And really, that's mostly because community members have a vested interest in the safety of their community. And we believe it's really important that community members understand their court system and also feel empowered to make changes that are necessary to their court process. A second main benefit we feel is accountability. So really making sure that all of the working parts of the court process are taking ownership over their specific choices and how they play a role in any injustices that we're seeing. And that can really take the form of judges, it can be bailiffs, it can be even elected officials and prosecutors. So really being sure that everybody is being held responsible for the choices that they're making, and also being cognizant of the choices that they're making. And third, as Jesse also mentioned, is transparency. We cannot stress this enough. We feel that it's incredibly important to ensure that individuals who are not parties to the case do have access to these court hearings. And it really gives us the ability to highlight safety concerns from our point of view, but also injustices that we're observing, and then make that known to the public. So we feel that those are really the most important benefits of court watching.
Awesome. Thank you. Thank you. Thank you. Thank you. Let me see. I'm trying to think. Do I want to kick it to Dr. C? Do I want to? I'm going to kick it to you, Professor Elizabeth, because you work with students, and like I feel like the work that you guys do is a little bit more special. I know we have a law student program in CourtWatch PG, and I can only imagine how much more streamlined and like efficient you have gotten down with your law students, because we only get to have them for a semester, but you probably get to have them a little bit longer. So big one question for me to you is, how can an individual court watching become a part of the system's change? And what challenges do students in particular face when court watching?
Okay, so first I want to make clear, you all do a lot more court watching than we do. On the one hand, we do it all the time, right? I run, just so folks are clear, I run a criminal justice clinic. So it's like a mini public defender office. So on the one hand, every time we go to court, which is multiple times a week, we are court watching. And I am constantly, it's just part of my students' education to say, to constantly point out different things. What did you notice here? Why did he answer the question that way? What would you have done differently from this lawyer? So that's all a teaching tool for me. My students are a particular slice of the community, which is to say, they're people who are going to be lawyers. Hopefully many of them will be criminal defense lawyers. Some of them may be prosecutors. Some of them may be real estate lawyers. So they're all members of the community, just like your folks are, but they also have a special role in the sense that they may well be some of the actors who you're looking to hold accountable later on when you see them play out in the courtroom. And certainly they are part of it right now. So I sort of view it as a two thing, like I'm definitely training citizens and I'm also training future lawyers. So there's this sort of everyday evidence. The systems change part is some of that, just right, you're training people for the systems, but it's more the stuff that, you know, when Jessie talks about doing a report every year, or Carolyn talks about the accountability, I don't think she mentioned it, but I think they do reports as well. I know Dr. Johnson's crew does letters, accountability letters to judges and to other policymakers and folks like that in the system. I know some of the law students who've worked with her have done op-eds. So that's more of the stuff that I'm talking about, sort of what do you do with the court watching data that you collect? So in my case, the only like really formal court watching program I did was I wrote an article where I had my students court watch every day, the same court for 5 weeks to see what happened in this municipal court. And it was a pretty, it covered a lot of ground. It was mostly about procedural protections for folks who are going through this basically poor person's court. And turned it into an academic article where, again, it was the same idea. This change comes from not just the actual watching of the court, which does filter into the community, but also the figuring out products to put it into, to put it out there. In my case, it was an academic article. I've done op-eds and things like that. So that's where I see hopefully some of the systems change coming from, when we sort of collect it and say, what is the story that this is telling us about the system, not just this particular incident, but wow, in 5 weeks, 5 different people were reduced to tears in that courtroom. Like that says something. And we use that to try to get folks to do things differently. In our case, I would say specifically, one of the things that happened specifically because of the work that we did in this court was lawyers weren't being assigned, public defenders weren't being assigned, there were all kinds of things happening. And it was just against the law. So we met with the chief judge and he was like, yeah, you're right. It was actually quite easy in the end, but somebody had to say the emperor has no clothes, and that's the systems change part.
I love that analogy, the emperor has no clothes. Goodness gracious. So
I think I didn't answer your second question, but I've taken enough time, so we can come back to that later.
Oh yeah, I'll come back to you in a second on that one, I promise. So I do want to kick it to you, Dr. C. So we've talked about a lot of the benefits of community and court watching. I kind of want to go around the room and kind of highlight, I mean, we do a lot of work, so I do want to at least highlight some of the successes that we've had. And I'll start with you, Dr. C, and I'll let everyone answer this question actually.
As far as successes are concerned, I can say personally that I've sat in now over about 3,200 bond review hearings since February 4th, 2020. And I was brought into this space, into this container by our executive director, Ms. Kiana Johnson. And she asked me to come on to be a court watcher. And it was quite interesting because at that particular time, when I first met her, I didn't have a voice. Like I couldn't speak, I couldn't talk, I couldn't function. And here it is, this woman that's making things happen in the community saw something in myself that, you know, the system stole from me. And I spent 3 years in a prison camp for a crime that I did not commit. And I totally came home with no self-esteem. I was, you know, it didn't matter about all the accolades that I received, all the awards, everything, all the work that I'd done in the past. It didn't matter. I had lost everything as far as my self-esteem, my voice is concerned. And she saw something in me. So I first want to give her honors for that she created me and helped pull my voice out. And so now I'm the director of CourtWatch Judicial Accountability. I also want to, you know, give homage to my good friend, Judge Joe Brown, that's on here. And last year, he and I met, and he went through my case, and he this after reading everything, he said that this was a travesty, what happened to you, and we've been friends ever since. And I can tell you that injustices happen in an empty courtroom, and that's what happened to me. I didn't want to tell anyone what I was going through at that particular time in 2015. I just knew that it was going to work itself out. I knew that I was innocent. Our justice system is our justice system. And I quickly found out that that was emphatically not the case. So as I sit in these bond review hearings from February all the way up to now, last year we would get cases 60, the most I've sat in one day was like 67 cases in one day. And now we're down to, we may see the worst day, maybe 15 or 17 cases in one day. So I can say that that to me is a victory that I've seen for myself, not to mention the awesome committees that we have under us. We have the Accountability Letter Committee, which sends letters like the professor was just saying. We send letters to the administrative judge, to the chief judge of Maryland, when judges are doing things that they should not be doing. We send letters to the state's attorney when the assistant state's attorney is not doing what they're supposed to be doing, the pretrial, head of pretrial, head of the jail, the head of the police department and their inspector general in their police department section, and also to the elected officials that sit on the Judiciary Committee. So everyone is fully aware every single week they're going to get 1 to 8 letters a week on what happened in the courtroom. And so with us holding these characters accountable, it allows a space for them to be watched, and they have no choice but to follow Maryland Rule 4-216.1, which deals with the bond reviews for the courts, the standards for bond reviews is what I'm trying to say. So we also have a social media committee. We have a database committee. We're working on our report now. We just had our analysis done. We got all our figures and numbers and all of that stuff together. Now we're working on the narrative and the stories and the language for the report that will be coming out around September. I hope not October, I hope September. This will shed light on what we've seen in the last year since COVID. And the fact that there is a serious disparity in our community that's happening to Black and brown people. And, this is like the pink elephant in the room, and people are not, they won't accept the fact that innocent people do emphatically go to jail. And even if you're not innocent, no one deserves to be in a prison, jail, camp, or cage. There should be rehabilitation. There should be programs. There should be services. No one deserves to be in a cage mistreated. It's just no way. And with Life After Release, we are an abolitionist organization. And so we believe no one should be in jail. We're not God. We don't know the circumstances. I can tell you about my situation, but I can't judge anybody else except that they don't deserve to experience what I experienced, and I was at a prison camp. So I'm going to continue to CourtWatch. Is very important. I'm going to continue to stress the fact that there should be a CourtWatch organization in everyone's community. No loved one should be sitting in a courtroom in front of a judge or a prosecutor or any of those actors in the courtroom alone. Again, injustices happen in an empty courtroom. Thank you. Edwan, we can't hear you.
Order. I'm going to go in the order: Elizabeth, Carolyn, and then Jesse. And same question, accomplishments that you can point to.
Like I said, I don't have an ongoing formal program for it except for my clinic. I think the accomplishment is with my students is that I feel like one of my actual learning objectives is I teach outrage. So you know, it's actually not hard. All you have to go and do, and those of you who've done court watching know that, go and sit there. I want to underscore something that Dr. Johnson said, which is that it's really not just about the innocent. Give me the guilty. The question is, like, how are we treating people in the system? And when I was in law school, I remember my supervisor saying, for all the injustices they will say that your client committed, it will pale in comparison to the injustices that get committed against them every day by the system. And every single day that I'm in court, that's something that I see and that I get the opportunity for my students to see as well. When we then put it into projects, into op-eds or other kind of writing things, then we're trying to shine a light for other people to see it as well. So every time we've been able to do that, I mean, I told you about the specific changes in that courtroom, which is to say, the article started out with there's a picture of a sign that said basically like, getting here, find your name on the list, check in, go talk to the prosecutor by yourself, you know, which is basically your plea bargaining session where they'll tell you how much you owe for whatever thing you did, and then come back in here and get your name called. And there were just so many things wrong with that picture. Now the sign, by the time, you know, the article came out, the sign changed. It was in English and in Spanish, and it said, you can do that if you want to. If you want a lawyer, let us know. You know, you can go talk to the, and honestly, how many people seek out a lawyer? I don't know. I don't know that many, but those who want to, those who are terrified, there's now everybody in that courtroom knows that there is access to a lawyer from legal aid if they want to, and access to an appointed lawyer if they want to. And that they don't have to go talk to the prosecutor by themselves. So that's the biggest accomplishment we've had. The rest is just sort of continuing to try to push the judiciary. You know, I wrote an op-ed last week, and one of the things that I talked about was, it was about lessons learned from COVID. And I said, hey, one of the things we were able to do, and actually I was inspired by Dr. Johnson, is having cameras in the courtroom. Can't we continue to do that? And can't we open it up to the public? Because that's something that's really been missing over COVID, which is that there hasn't been an audience for the most part. And the fact that we've been able to go virtual for this time suggests we can do that. We can open it up to people publicly, and that's something that, you know, we should be able to court watch all the time. It's our public institution, and that's how we hold people accountable. And again, it's that sort of both the public lesson and the private learning for the citizens.
Perfect. Thank you. Thank you. Carolyn, check in. You got it.
So for CourtWatch Montgomery, on an average year, we are usually monitoring at least 1,000 cases, generally over that for our specific domestic violence focus. And that can be both protective orders as well as criminal hearings with the domestic violence focus. And with that, we're collecting data in all 1,000 of those cases. We combine them into our database, and then we publish reports. And as the other CourtWatch organizations, you know, we publish reports on our findings, but also our recommendations for system improvements and policy changes. And then we also send letters to court personnel, administrative clerks, administrative judges to really outline any issues that we're seeing, but also provide a collaborative environment where we can really work with the courts and say, we're watching these cases, we see these trends, we have objective data, and we have input, and we would like our input taken seriously as community members. So some main accomplishments for us are things, you know, being instrumental in real concrete changes to court policies. Since we do have a domestic violence focus, we really are focusing on safety and respectful courthouses for all parties. And so one part of that for domestic violence dynamics is really having staggered exits. So ensuring that two parties are not leaving at the same time and that there aren't any dangerous circumstances. So presenting reports on how many people are leaving the courtroom at the same time, as well as how we collect time. So when one party is released and when another party is released. And we do have a lot of cases where people are, you know, assaulted in parking lots and things like that, just because they are pretty complex
relationships between the parties. So we presented that to the court, and now it is common practice to have staggered exits. So a petitioner gets paperwork, is released, and then 15 minutes later, a respondent gets paperwork and is released. And really, that is for safety and respect on both sides, just to ensure that that everybody has time to kind of cool down and move on. We also were really instrumental in starting the Safe Passage Center in Montgomery County. So we learned from our observations that courts were ordering our petitioners and respondents to have custody exchanges, but there was no safe place to do so. So a lot of times, petitioners and respondents, which is what we call them in Montgomery County for protective order hearings, petitioners and respondents were exchanging children in at home, in mall parking lots, and unfortunately there were a lot of cases where violent incidents did occur. So we thought it was a very reasonable solution for the county to provide a safe place with cameras and lighting, and also for monitored and supervised visits and exchanges. So we were really instrumental in getting that county funded building started, and now there's a wait list for it. So the impact of that for the community has been huge, and it really, again, it's important for safety of both parties as well as children. So those are some of our main accomplishments.
Awesome. Thank you. Thank you. Last but not least, save the best for last. Go ahead, Jesse.
So like I said, a lot of our work is summarized in an annual report that we release in May. And so a lot of the change that we've been a part of has come on the heels of the report release. So we released in our report that the drug lab at Orleans Parish Criminal District Court was not using scientific confirmation tests on drug tests, and were incarcerating people based on the results of these tests. And so after we released our report, the state Supreme Court changed the judicial canon that required set new levels for scientific scrutiny for these drug tests. We also reported on the lack of access to language interpreters in all levels of the court. And then we were able to work with the New Orleans City Council to actually fund full-time interpreters for Spanish, Vietnamese, and part-time interpreter for American Sign Language. And so it has changed the way that court works with the accessibility. We reported on material witness warrants, which was a practice our last district attorney was using, where he would incarcerate survivors of domestic abuse and sexual assault in order to force them to testify in their own cases. And we worked with the state legislature to actually pass laws that made that process significantly more difficult. Unfortunately, it's not totally off of the books, but it's a lot harder to use now. And that was something that also came out of on the heels of our report. And then we reported on some judicial conflict of interest that was essentially judges getting contributions from companies that do ankle monitoring, and then requiring defendants to use that specific ankle monitoring company. So that, was something that helped, I think, shape the current outlook of, or the current makeup of our criminal district court, the way that we reported on that. And the thing that all of these things have in common is it's based on data that was collected by our court watchers that sat in court, and that data went into a report, and that's how things changed in Orleans Parish.
Oh my God, I can't even believe it. You would think that the craziness knows no bounds with these judges. They already have immunity. Most of them are impossible to get rid of, and then they start lining their pockets and just pumping people into the system. Go figure. So I do love that too. I want to talk to you more about the changing of the judicial canons. That sounds like it would be a very fun process. But I do want to kick it over to you, Carolyn, and also I do want to shout out Reverend Anderson, because I know she's in here. She's all over the chat right now. She is the executive director and the kind of the backbone of CourtWatch Baton Rouge over in the East Parish, and we're so appreciative to have her here. But I do want to kick it over to you, Carolyn. We did talk about the accomplishments of the organization. I do want to kind of get to the center of the values. So, CourtWatch Montgomery County has, like you said, you guys' specialty is in domestic violence cases. So I kind of want to give folks some background on the mission, philosophy, values, and kind of why you guys chose that to be your specialty.
Sure, thank you. So our mission really is to reduce intimate partner violence in Maryland by way of ensuring that victims have access to responsive justice and vital services that help stop abuse. And so with that, obviously, as everybody else, we have a team of volunteers who go in and collect on protective order hearings and criminal hearings with a domestic violence focus. And the entire purpose of that really is to have this wealth of data that is unique to Montgomery County, that is unique to intimate partner violence, where we can provide very specific recommendations to the courts and also to elected officials, and to improve safety and respect of the courthouses. And so while we have a focus on our courtroom safety for domestic violence victims, it really is rooted in our history and our founders. And so our two co-founders actually began as domestic violence victim advocates. So they were accompanying individuals to court, and they were seeing that even though every survivor has their own story that's unique, that they were all still facing systemic barriers as a whole. So we really felt that it was important to have an organization that was there specifically to address these larger systemic barriers that for having accessibility to court physically, whether that's having money to pay for transportation, whether that's having childcare, the ability to have paid time off from work to be able to go and file and return to court time after time. So we are one of the only domestic violence court watching programs. And so we really do have this unique data that's for a very specific population. And with that, our main values really are also kind of the benefits of court watching. So transparency, accountability, and then safety and respect. So we feel that those are very attainable values, and our philosophy is really very inclusive of all parties who are experiencing abuse. And we do feel that we find a lot of very meaningful recommendations and have a really positive impact in our community.
Awesome, sweet deal. Thank you, thank you. Honestly, I want to kick it back to you, Professor Nevins, because we there's an answer that there's a question that we skipped over. I want to make sure I get that question answered before we get out of here. And so I believe the question was, how can we did talk about the individuals who can benefit the system. I think the other question was, what challenges do students in particular face when court watching?
Yeah, I think, this is Jesse and Carolyn probably, and Dr. Johnson have a good idea. Working with volunteers is challenging, right? Some volunteers are incredible and go above and beyond, and others have a mixed level of commitment to it. Students have that issue that, Jesse's talking about college students who are in one place for 4 years. I've got law students who are there for 3 years, and there's a vacation in the middle, and then there's summer, and then there's jobs, and it's by definition a transient population. So, my project was very limited in time, and even then, it was something that was on top of all the other work that they're doing, and getting them on this is, I think, again, a problem with volunteers generally, but getting everybody on the same page and doing the same thing, it's just that much harder when you're dealing with students who are pulled in different directions and not necessarily, some students must be amazing and probably showing up all the time for your projects, but for this one, it was hard because I tried to sort of keep it narrow, and to some degree, keeping it narrow meant that it was kind of went to the bottom of the list. But there are other kinds of challenges, right? Most students are young, and many of them, although it's probably true for a lot of people in the community too, don't have sort of the life experience of seeing what happens in a courtroom. For students of color in particular, going in and seeing what that feels like and how folks, particularly people of color, are treated in a courtroom can be traumatic. I haven't had a lot of experience with that personally for this particular project, but it's definitely happened in other places. I've had students walk in and they're mistaken for a client, right? Or for, you know, they're not viewed as students or as lawyers or as anything like that. And that can be traumatic for them too, feeling like that their identity is being questioned. And then it works both ways. This is always true, I think, for court watchers. I've got a colleague from the University of Mississippi, and he thinks when his students walk in and they're very well marked and they've got like badges and it's clear who they are, and they walk in, that they form a real that folks are nervous having them in the room, and that's actually just the being there changes the behavior. I feel like that works both ways. On the one hand, you want to change the behavior. On the other hand, you want it to be changed all the time and not just when somebody's there. And for students, that can be kind of a challenging thing. What is their role when they walk in? How much should they stand out? How much should they introduce themselves? Should they try to be present in a way that folks know who they are or not? And again, some of these are sort of, you know, they can be sort of challenging roles, particularly for folks who are younger and have less experience. On the other hand, as Jesse pointed out, right, like people are always better than they think they are. And it's not, you know, the challenges that folks face end up being more logistic, right? I can't hear, they're going too fast. You know, and all those kinds of things, which are part of the problem in the first place. And that's another kind of challenge that students face, which is just being able to do the job that you're trying to do. You know, we keep talking about data, and this is very imperfect data that we're all collecting, very imperfect, because it's so human and it's so fast and it's so distant and it's not designed to be collected. But that's why we're trying to do it. And that's why it's so important to do it on the grounds in these court specific ways.
I love that. I love that so much. Jesse, you wanted to stack on this.
Yeah, something you said really resonated for me. Is someone who works with multiple different universities, the character of every university is different. And so that is one of the things that I, you know, really have to stay on top of. If I'm taking a group of students in from one school, they, you know, have significantly fewer experiences with the justice system, with them and their family members, and they will get their minds blown by what they see. And they just walk out of there wide-eyed, like, I had no idea it was this bad. And I take in students from another school, and they're like, yeah, I've seen worse. Like, so something way worse happened to my cousin, let me tell you about it. So, you know, it's I think not necessarily a challenge, but like I try to look at that as an asset. Like every school that you work with is going to have a different character and different qualities they bring to the table, and you know, something that you can work with that student group to pull something out of the experience that another group won't be able to do. You know, we've had different groups, you know, mixed groups, like half of one university, half of the other. And then, you know, some of the students are like, did you see that? Did you see that happen? Like that person was talking to somebody in the witness box and they weren't saying anything, but they were using hand signals. And, you know, just the level of detail that different groups can focus in on is just fascinating. And so that's just something to look for and see what you can work with that particular student group to get out of it that another group might not.
Thank you, Jesse. Dr. C, you wanted to stack on this. And also before you stack, I believe there was a shout out that needs to go out to my favorite apple in the whole world. And it ain't grandmother Granny Smith apple green, it's Fiona. The Fiona apple is in the building. And I wanted to make sure I gave her a personal shout out, one of our CourtWatch PG volunteers. And I'll kick it back to you, Dr. C.
Yeah, I just wanted to add, we have worked with about 53 law students and about maybe 4 or 5 different law colleges. And a few times I experienced a couple of the law students did not want, you know, their names mentioned or be seen or anything like that. And that they were afraid because of whatever law that they were going into, they was thinking that it was going to affect their career. And I just thought that was kind of weird. So I would love for Professor Nevins to expound up on that, you know, which we did grant, you know, their wishes and not list their names or talk about them or, you know, block their numbers so the numbers can't be seen and things of that nature. But students that that are court watching is very important, that, you know, we need them to go off to be great attorneys, and we need them to go off to be great judges, and that this is not something to be embarrassed about, or this is not something that we're doing that's wrong. The fact of the matter is we're trying to balance the scale that's unbalanced. And so, you know, I was, you know, taken back a couple of times. It only happened a few times that some law students was like, hey, I don't want no one to know. And but most of our law students are just magnificent, and they want the world to know, and they want to sit on committees, and they want to do whatever they can to help, you know, our court watch efforts. So Professor, if you could just explain why a few students may feel that way, and how can court watch affect their career moving forward?
Lord, I don't know. Honestly, I mean, one of the things that separates our democracy from others is that we're supposed to have open courtrooms. And so being a citizen and watching and reporting what you see is a privilege of living in this country. To be honest, it's not something you can do everywhere. But I don't know, law is a fairly conservative profession. And I think folks worry about, you know, if I want to get an internship with that judge, I don't want to be seen as criticizing that judge. If I want to go to the DA's office, I don't want to be seen, or the state's attorney, I don't want to be seen as criticizing that office. I mean, arguably, right? Like, if everybody's doing their job, they're not getting that critiqued. Or there's not particularly a fair critique if people are doing their job, although I'm sure we have different opinions about what's a good job and what's a bad job. So I can't really answer for those people because I don't feel that way. And my students in general have signed up, right? I have a particular crew that has signed up to do this kind of work with me all semester. But I'll tell you, you know, I have a lot of students who come in, they are kids of cops and detectives, and they wanted to be prosecutors their whole life. And they still want to be prosecutors when they leave. Being able to see the injustices in the system doesn't necessarily make them doubt what they want to do. They just want to do it better. And they want to, you know, there's a role for prosecutors who are doing their job well, and folks who are upholding people's rights and being fair and seeing the humanity in folks on the other side. So hopefully folks can be persuaded that that's what you're doing. We're making the system work the way it's supposed to work. This is part of making the system work, but can't account for everybody's fears about, you know, their future and thinking that they're going to have an effect like that. But, you know, if you are coming out hard on somebody, you can imagine somebody being like, I'm not going to be able to get a job there. I guess I can understand it to some degree, but I don't know, query why they're in the position in the first place, why they're in the court watching field if they're worried about things like that.
A friend of mine always tells me when it's right, and when it's wrong. So, you know, it's one of those things you got to think about. It's a principled struggle. And on the mindset of principled struggle, actually, I want to kick it to Carolyn, and then I'm going to end with you, Professor Nevins, if that's cool. So here at CourtWatch PG, we are in a principled struggle. As an abolition community-based group, we know that there is really no such thing as crime. There is only harm. So, Carolyn, how does your group hold the courts accountable to actually providing the restorative justice measures that bring folks that have suffered from the interpersonal violence? I know you guys deal with very particular cases of that interpersonal, so I wanted to kick that one to you.
Yeah, so again, as an observational group, we don't have a direct connection to working with victims. So we really rely on our partners for a lot of the actual like ongoing support, therapeutic support, social services. But again, sitting in the courtroom, it's hard not to notice when something is directly negatively impacting victims. So we really like to focus on things like ensuring that all petitioners who are coming to court have the needed support while they're there. So one of the things that we've noticed with our years of monitoring has been having an interpreter who's present for both parties, when really what is a best practice for domestic violence court watching is to have an interpreter for each separate party, so that the parties don't have to stand next to each other, and or having the ability to have these remote hearings, as we've seen during the pandemic. So we really focus on tangible solutions to making sure that everybody is comfortable, because we also know that domestic violence is is seriously underreported, and so we are already looking at a population who's comfortable coming into the court system. So we are cognizant of that with our recommendations, that coming to court isn't the answer to everybody. It isn't the picture of justice to all victims, and trying to be sure that the recommendations that we're providing can be unique and tailored to individual life experiences. And we especially see that with our criminal hearings as well, too. There are a lot of domestic violence relationships where the victim in the case does not want to testify against their loved one, that they did not want the police called, and they did not want to be part of the criminal justice process, because obviously that has serious impacts for their relationship with that person, whether that's having children in common, or sharing financial expenses, having a home together, still being in love with the defendant at the time. And so we really try to take the mindset that every survivor is the expert of their life and their experience, and that the court system should empower them to make unique choices that are tailored to what they feel is responsive justice for them. And to be sure that we're not forcing different opinions, or forcing our personal opinions on what we think is best for survivors, and making sure that they really do have that self-determination to make those choices. And as Jesse mentioned too, having the ability to not testify against or against the person who is the alleged defendant, it's an important part of that power dynamic, and ensuring that people have the power to make changes and make decisions for their own life that are not being forced upon them. So we try to take all of our decisions and all of our reports and look at it through that lens.
Cool. Thank you so much, Carolyn. I do want to kick our last question to you, Professor Nevins, and then we'll get a foreword from Judge Joe Brown, and then we'll do our Q&A session. So final question for you, Professor Nevins. What advice would you offer to those seeking to collaborate with academics or others on research projects?
So I think it's hard because folks often have a full plate, whether it's academics or nonprofits, but the folks that I know that have done this are people from the professor I was mentioning at the University of Mississippi. He brings through the MacArthur Justice Center, brings lawsuits, and those lawsuits are often based on the observations of folks who've gone into the courtrooms around the state. The same is true for the Southern Center. For human rights, folks have done lawsuits and reports out of that. And that's essentially what I did, right? So you want to find out who in your jurisdiction is doing this kind of work, right? Who's doing lawsuits that's trying to hold, who has aligned interests, whether it's a victims' rights group for Carolyn's folks, or folks who do, not necessarily death penalty work, but maybe, criminal justice reform type work. And is there a partnership you can do there? Because one of the things is, it's one thing to have the people on the ground, as again, I keep saying, to have the people on the ground doing the observations has a lot of good. It's better, and it can be magnified if it's turned into something that becomes more public. And that's a big piece there, right? Do you have the staff, whether it's in your own organization, to put together a report, or can you partner with somebody in an organization? So find out who in your community is doing that work. It's not like every academic is waiting around for an opportunity to do this kind of thing, but maybe they are, or maybe they would be interested in it. I would imagine that the more you can present some ideas of some of the things you've actually already seen, rather than going in and saying, like, we're thinking about court watching, would you write an article on us? The more you can come in and say, there's this problem with the visitation for folks who are coming in from different sides, or there's a problem with release people following the law when it comes to bail reform, the bail statute. So the more I think you have some basis for what it is you're looking for and what it is you can offer them, we can train the people. We've been doing this for 2 years. We have, the more you can offer what you can do to these organizations, probably the more likely they are to be interested in biting on to it. But I think coming to the table with what you can offer, either in terms of a story and or in terms of, troops on the ground, I think is going to make that partnership more likely to be successful.
Heard that. Don't reinvent the wheel. That's what I heard. Come, don't reinvent the wheel. So definitely, thank you so much for that, Professor Nevins. I appreciate you so much. I appreciate all of our panelists, and I do want to, before we get into our Q&A, I want to give a forward and a special moment for Judge Joe Brown to speak his piece today to this lovely group of folks. So you have the floor, Judge Joe.
Young Mr. Whitehead, I agree that the panel is lovely, but not yours truly. I'm a homely old man. Anyway, I take issue with you on that. The ladies are lovely. Now, this is my 6th decade involved with the law, and I just have some observations, and I'd like to put them on all of you. I'm glad that you're doing what you're doing. As we've had pointed out very eruditely, we have a right as citizens to a public proceeding when we have criminal matters before some official institution. I'd like law professors and anybody else who has the time to impose on the students or yourself a reading of Alexis de Tocqueville's or de Tocqueville's 1843 treatise, Democracy in America. He makes an interesting observation. He says Americans rely upon their courts as their principal form of entertainment, whereas Europeans rely upon the opera, the concert, the ballet, the play, etc. And because we did that, what happened is we had an intimate and colloquial knowledge of the law, which helped us to be good functionaries in the vital part of the system that we as citizens play, that is jurors. And also those who have some influence on the selection of judges and on the representatives who pass the laws and set the form for the system. That said, he also notes there are 2 types of lawyers: those who promote the status quo, that's the overwhelming majority, and those who rock the boat. That category also includes those who ensure that the system functions. And de Tocqueville said in America, there's only one real aristocracy. It does not consist of a landed class. It does not consist of the rich industrialist. It is those lawyers who form a brotherhood, or I would surmise we should say brotherhood and or sisterhood, of those who are trained in the law and what it does. Now, I'll make an observation. In my 6 decades of law, and this is my 4th since I became a judge, I would remark that a goodly portion of what I had to do did not come from law school, but from what I learned in the 5th and 6th grade in elementary school. Our educations have become deplorably deficient, and I have noticed a horrendous and accelerating trend in the public to be very ignorant of their law, their courts, and their Constitution. That's a shame, because the Constitution can be read by a typical high school graduate in less than 15 minutes. Most judges and most lawyers have never actually read the thing, though they've studied common law. That said, putting young people, old people, seniors, whatever, back in the system as court watchers once again opens the door to the public, and you have recourse from what goes on inside the courts that spreads out to the public. I would make a suggestion to all of you. You not only watch where you are currently ensconced, that is in the lower courts, but you also vigorously concern yourself with juvenile courts, and also with the higher level trial courts that do have the power to grant motions, deny motions, etc., review bond settings and such like. That said, please also, if you get in there, look at what goes on with jury selection. As you are probably well aware, there is a great discrepancy in the quality, nature, and value of the various and sundry people who put on the bat cake and capes and sit on the benches. All judges are not the same. Now, I have been prosecutor and chief public defender for the city of Memphis. And I did a lot of volunteer work for the public defender's office when, in quick succession, two of my law partners became the chief public defenders. One of those was handling murder cases. I trained the Capitol Defense Team for the Memphis and Shelby County Public Defender's Office. I think personally I tried 42 first-degree murder cases where the death penalty was demanded, and basically I have no clients hit or on death row, and most of them walked. But my job as either prosecutor or defender was not to put somebody in jail. My job was not to get the guilty off. In both roles, my job was to make sure the due process of law was followed, because that is the most important thing, because it impacts all of the citizens. There is a presumption of innocence that's good. There is a duty of the prosecution to ensure justice, a duty upon the defense to ensure justice, because if we let the criminal justice system get out of control, the mechanisms that it has in place can also easily be used for political and social persecution. That said, I would also ask everyone to consider there is this concern for a thing called public peace, dignity, and order. There are a lot of citizens who have an abject fear of going outside of their homes because, frankly, where they live is a dangerous place that quite literally was on the level of danger that you might have found in downtown Baghdad in 2003 or 4.
What are you doing?
So,
I'm sorry, Manny Petty.
Oh, well, I heard somebody. The educational aspects of what you will do extend far outside of the courts. Now, we have to get back to this thing of courts being a primary source of information by focusing the attention of the public on what happens. I have had occasion to try many cases in outlying counties, and these small ones where they'd seat 250, 300 people inside a courtroom. And when there was an interesting trial, they would have loudspeakers on the hall, well, on the walls of the courthouse, which was also usually the city hall. And people would be outside in good weather on picnic blankets, eating their picnic lunches, listening to the proceedings. Now, that promoted a colloquial understanding of our system. And right now, the bunch of you is on the front line when it comes to spreading that colloquialism out to the public. You're seeing how it works. Now, let's see if there are any more notes here that I have that I think I should cover. One thing I would suggest that you do is understand that there is a certain concept inherent in material witnesses that a lot of people miss. See, the primary interest of the criminal justice system is not the victim, it's not the defendant, it's the promotion of public peace, dignity, and order. And if you peruse an indictment in most states, or certainly for the United States of America, it says on or about such and such date, John Doe did against the public peace, dignity, and order of the state of Maryland, the state of Tennessee, the state of New York, the United States of America, commit the following alleged acts. So when you have a material witness and it's the state's objective to maintain public peace, dignity, and order, the interest of the many may not coincide with the interest of 1, 2, or 3. And occasionally there is what you call the setting of a material witness bond. In other words, you will post this bond guaranteeing that you will show up for the duration of the proceedings because the state has an interest in your testimony as a material witness, or if that won't suffice, you will be locked up until your testimony can be offered. See, what we have in the system when you actually get immersed in the runnings is we have an underfunded system that is not sufficiently manned with insufficient resources. And unfortunately, a great deal of it is tied up by false allegations, or if not false allegations, allegations where somebody is having a spat, but there's a serious problem. So they come in and say, we don't want to prosecute anymore, let him go. Well, he's been punished enough. He's sat in jail for 4 months. Well, what happens oftentimes is that person is released, and then 9 times out of 10, if something happened after that, you'd get a public uproar when somebody gets killed, maimed, or grievously insulted or injured because the state did not deal with its obligation to make sure that somebody out there who potentially or allegedly violated the public peace, dignity, and order sufficient for probable cause to be discovered was not brought in and dealt with. Now, those are considerations. I just want you to deal with it. There's also another thing that I have noticed over the last 6 decades, and we have what we in the system call boutique or designer crimes, where depending upon the era and what the social circumstances are, there are crimes that people are very much concerned with. And it's rightful that you have these concerns because they are important issues. But don't throw the baby out with the bathwater and without realizing it, advocate the abrogation of due process. Now, that is a balance, so we need to keep that in hand. There are things that need attention. There are things that we need to do, but let's not make the system that we are disturbed about, that delivers injustice all too often, become something that without our conscious intentions becomes worse. Now, that said, good for you. And one other comment about the law students. The way to become a big time lawyer is to get the controversial case and kick butt on it. And people say, I need him to represent me. And I am just absolutely astonished at the lack of fortitude with today's young lawyers who are scared to do things. Son, you want to take this case? I can give you a referral. Oh no, Judge, we can't afford to jeopardize our careers. Now, what he does not know is this young lawyer is being offered a retainer from, say, a group of residents who are prepared to pay him $1.5 million fee. I'm not going to tell the fee, so he's running off because he's afraid, but he's never had a fee that big. So you just threw away $1.5 million because you didn't have the balls, which are the nerve or whatever it may be. You know, I'm old school. Excuse me if I say things in the old time way, but you got to have nerve. That's what we do. Law is something that is unique to the United States of America. Every citizen has a vested interest in making sure the law works. And if you have availed yourself of this training and education that puts you in the position of being a doctor of law or a lay cognoscente of law, then you have an obligation to yourself and your fellow citizens to be vigorous, because there are people that died on battlefields, on streets, and in wilderness areas trying to get this country to be what it is today, even with all of its flaws. But they made sacrifices, and we can make those sacrifices too. That said, excuse the lecture. I can't help it. I used to be a law professor way back when. So, Here we go.
We love you, Judge.
We appreciate your words of wisdom, Judge. And I wanted to point out to you real quick before we go into our Q&A that I keep a little copy of my
The
Constitution.
Lexus.
Oh yeah, I keep my little Constitution
Yeah.
with the Declaration of Independence on me at all times. Stays in my glove.
May I make one more suggestion? All of you, go down to the bookstore at the local law school and buy a copy of your state's rules of evidence and procedure. And you will find that it gives you an up on everything you're listening to. And a whole lot of law students and lawyers and judges never get that. Get the rules. They're really thin little pamphlets. Highlight them and footnote them as much as you can, and you will find you're on top of the game. I tell that to each law student. Also, tell your law students to look at Westlaw. And when they're having a rush to get their homework done, go to the library, pull the case down, turn to the first page of the case, Xerox that, put it in a loose leaf notebook. You have a one short paragraph synopsis of the case and one or two liners on the holdings of the case. It makes life much easier.
I'm so glad I'm recording this. I'm so glad I'm recording this. I'm going to go back and look at this later. Thank you again, Judge Joe Brown. I do want to pass it off to the audience for a bit, just for some Q&A. I wanted to start with you, Ms. Carroll. You had your hand raised earlier. Please unmute. Go ahead and unmute yourself and ask your question if you had one.
Yes, this is Carol Jackson. I was invited by Dr. Thomas Johnson, and my question is, for pro se litigants, why has any of your court watchers noticed a difference in the judge or the prosecuting attorney when they come across someone who's willing to defend themselves versus have counsel? That's it.
I would say I heard your question, and I want to go ahead and knock on that one for a second. Yes, oddly enough, a lot of the times, and I will use Judge Heffron in Prince George's County as an example, he is super duper emphatical about and very methodical about when folks want to defend themselves. He usually he asks them a few questions to see if they are going to be able to walk themselves through the case process. And then if they, through the 3 or 4 questions that he asks, if they can't answer them, he literally lets them know, hey, so I'm going to give you some advice here. You've got a really good PD and they've been on it all day today. They have made sure every person has gone home. Do you want to represent yourself now that you know you got these questions wrong? Or do you want to pass it off to the PD who's been making sure people have been going home all day today? And so 9 times out of 10, we have, 9 times out of 10, the loved one will eventually say, you know what, I'll take that public defender. And Heffron will 9 times out of 10 make sure to let them go home, regardless of.
May I interject here from a pragmatic point of having seen this? Sure. The biggest pain judges have is defendants trying to represent themselves. There's an old thing for lawyers. The lawyer that represents himself has either got a fool for a client or a fool for a lawyer. Now, I've been doing this 6 decades. I've got 4 or 5 lawyers that represent me because there's objectivity. So when you have a pro se defendant, you know that the proceedings are going to be fraught with unnecessary error. People are going to do things that are unwise. They're going to get emotional in their case. They aren't going to be objective, and it's a mess, but they've got a right to do it. So, it's a pain.
Does that answer your question, Mr. Jackson?
It does, but I mean, a lot of the cases I'm dealing with are civil cases. Wrongful foreclosure or trying to sue banks and things like that. Not necessarily criminal. As far as like in Dr. Carmen's case, and even in my case, where conspiracy for some reason is a big thing when it comes down to the federal government and trying to get people silenced. So they nothing or no idea, no knowledge of, but they throw the conspiracy thing in there. But for my case, for my question, it was kind of mainly for a civil case. I understand, yes. On a criminal case, yes, I'm gonna go ahead and go with the PD, or I'm gonna go ahead and, if I can afford it, get me an attorney. But when it comes down to civil case, have any of the people on the panel ever just said in civil case?
No.
And we
Some
only do
people
criminal court.
others that represent themselves on civil cases, and some states have small claims courts. Some have small claims courts where lawyers are not allowed to practice. So, yeah, it depends. Civil is different. It's just money. It's not your freedom and liberty. But yeah, still, your choice.
Cool. I'm gonna say I did have a couple questions in the chat here. Okay. Any thoughts about the possibility of offering court watching as an alternative to jury duty? This person said that they had done both and that court watching is much more revealing and powerful. Anybody want to take a crack at that?
If you're a good
my
court
suggestion
watcher,
would be
sure as hell would love to have you sitting on a jury, because as it is right now, out of every 5 juries, 3 of them are great. One of them, and 1 out of the 5, they act like they lost their mind. I always let the lawyers and the court, I would get in and I'd let everybody talk to the jury after the verdict. And you get this. Lawyer says, don't you think there was reasonable doubt? Oh, yeah, sure. There was a lot of reasonable doubt, but that's because we felt you smart lawyers kept us from finding out why the police arrested him. They must have had some reason to arrest him. Like, wow.
Jesse, you want to go ahead?
Yeah, I'm my gut impulse is like you should do both because they're both really important, and it's one of the things we talk about extensively in our training is jury selection and how important it is, and we actually have a great organization down here in New Orleans called the Juror Project that is putting a lot of attention on the imbalance in jury selection. And one of the questions that we consistently ask is like, if you were on trial, would you want someone like you on the jury, or would you want somebody who wasn't able to find some way to weasel their way out? Invariably they say like, no, I would want somebody like me. So yeah, I mean, you should do both. Jury duty is really important, and we need people who are smart and fair and impartial and committed to justice to show up and sit on juries.
I usually say the same thing about voters and jurors. I love a good juror and I love a good voter who goes out and consistently does their thing, but I also love one who's educated and knows what decision to actually make and the impact of their job. I think Judge Joe's saying something. Let me see if I can. Goodness, let me find him real quick. Just hit the microphone, Judge Joe. Thank you, Jesse. While I'm waiting on him to unmute.
Okay, unmute. How
There
about
he
that?
is.
Hear me?
There he is.
One thing CourtWatch can do, there was a young Jewish lady about 28 years ago now who used to be on a local CourtWatch. And she got perturbed at the lack of wisdom shown by some lawyers when they would try to select a jury for, say, something serious like a murder case. So she approached me and I was kind of surprised. She had a 28-page questionnaire. She's not a lawyer. She's college educated, but not a lawyer. She was just on CourtWatch. And we wound up adopting her 28-page questionnaire as a standard pass out to all prospective jurors on capital or first-degree murder cases where life without possibility of parole was being demanded by the state. And she was very perceptive about it. And she brought somebody else in on a court watch thing and who was in there with her. And they wound up coming up with some jury selection questions that, frankly, a lot of the judges just automatically passed out when you had a panel full of prospectives. So being involved in the court watch thing gives you an insight that you can use to contribute directly, like this young lady did. Her name is Julie Phineas, and she's out in Los Angeles right now. She does other stuff for civil lawyers, but I commend her any chance I get for stepping forward and taking up some of the slack.
Thank you, Judge Joe. I do want to spend our last 4 minutes together and pass it to our Executive Director of After Release and CourtWatch PG, Kiana Johnson, for some parting words and a giant thank you to all of you.
Yes, thank you so much. I've been off and on of my camera since I've been on the but I thank you all for coming. I'm actually at the Black Votes Matter here on Nation's Capitol with a couple of our House representatives and some of our senators and stuff down here talking about Black Votes Mattering. And so having each and every one of you come out and participate and talk about Court Watch with us is very, very important. And it's a part of the vision that I had when I sat inside of a prison inside of Maryland for two and a half years. And I was just wondering what happened. I thought that justice was an automatic thing once you entered into a courtroom. But during my own experience, I learned that that's not the case, and that Court Watch is super important to ensuring that some level of justice is actually being done. So I want to thank you all again for coming on. Like Carmen and Edwin have stated, we are an abolitionist organization, but that doesn't mean that we don't believe that there's absence of accountability, right? We do believe that folks need to be accountable for any harms that are created or any harms that people inflict. We should be able to atone for those things. But what we know for certain is that our criminal legal system right now, as it stands, is not in the business of making people whole. It's not in the business of creating any real structures or things for us to learn and from or rehabilitative. It is absolutely punitive. And that what we are doing, we are creating a cycle of individuals and putting them back in the street, much more dangerous than they were when they left, right? And so we want to just acknowledge that. We want to thank you all again for being here. And I look forward to finding an opportunity and space to collaborate with each and every group that's here today so that we can continue to grow and become larger and be able to be a collective force to deal with. Because I will say this, in Prince George's County, since Court Watch has been a thing that we've been doing consistently, the culture of our courts have changed drastically within 1 year without having to pass any legislation. And I think that is very key to note, because you hear folks saying, oh, go out and vote, oh, pass laws, and they think that these things in and of itself will get us free, when in actuality, that's not what's going to get us free. What's going to get us free, what's going to get us closer to anything that looks like justice, is that we are holding folks accountable to, like what Judge Joe Brown said, is to the Constitution, right? A lot of the times, a lot of the issues that we're talking about are constitutional violations, and that our judges and our lawyers are not adhering to. So we can do this. I believe that we will win, and I just want to thank you all for being here today. I appreciate you all.
Thank you so much. Thank you so much, Kiana. We got final 30 seconds. We've got Tony. Tony, what's your question? You got 35 seconds. Go for it.
It wasn't so much a question. I've been, like, say, a tenant advocate and mediator for like the past 20 years with judges and prosecutors. It's more or less like, that's one thing that we always miss. We miss, like, say, the person that we are defending. It's like when we are asking them, I need you to tell me when, where, what, and why, everything that you know, it gives us, like, say, more time to, like, say, go over, like, say, what it is that we need to go over in order so we can get things right. for when we go up against the judge and the prosecutor and stuff to get them out of there. So my thing is, it's like, that's the one thing that we also miss as well when it comes to, like, say, defending our clients and stuff. And I dropped the mic.
Thank you, Tony. Well, we are at 1:31. I want to be super respectful of everyone's time. Thank you all again to my panelists, to the audience, to Judge Joe Brown for popping in here with us today. I appreciate your presence, sir. And you guys have an amazing Saturday afternoon. Until the next third Saturday, this has been Edwan Whitehead with CourtWatch PG. Until next time, y'all. Peace and chicken grease.
Thank you, Edward. Take care, Dr. Carmen.